Good evening. How's everybody doing? Let's light up the darkness. Who's in the house on a Tuesday, Yom Shlishi? Yehud in South Carolina, Bill in Missouri, Stephen in New Hampshire, Sharon in New Jersey, Shandora in the Bronx, Joe in the Inland Empire, Nancy in North Carolina, Randy in Florida, Paul in the Great Northwest, Bella in Florida, Guy in Ohio, Shauna in Canada, Lucy in Minnesota, Melissa in Great Neck, Marjorie in Georgia, Ella, Chaim in Florida, Marie in Freeport, Melissa in Great Neck. Welcome, everybody. Excuse me. Okay. Our daf today is page Lamed Daled. Here, opening, actually on 33b, but our daf is 34. And we are opening chapter 3 today here in Tractate Bava Metzia, the 22nd volume of the Talmud. Mishnah number 1 of chapter 3. In the case of one who deposits an animal or vessels with another, who is acting as an unpaid bailee. So often we've talked in our journey through this tractate about the unpaid bailee, the paid bailee, the borrower, the renter. Now we're actually going to establish those laws of liability when you deposit an item or lend an item to another person. And the Torah has 4 cases, and they have different levels of responsibility to the owner of the animal or vessels, right? Who is doing who a favor? If I'm asking you to watch my goat for me, because I'm going away and the goat needs watching. Okay, so if I'm not paying you, you're doing me a favor, and you're going to have the least level of liability and responsibility if something goes wrong while I'm away with the goat. Basically, unless you were flagrantly negligent, the loss is on me. If I'm paying you to watch the goat, not surprisingly, you have a higher degree of responsibility. Now, if the goat is lost or stolen, it's on you. You are liable. You have to pay me. If you were renting the goat from me, so I'm making money on the deal, that's going to affect your level of liability. If you're borrowing the goat from me, I'm doing you a favor. I'm not getting paid. You're going to have the highest degree of responsibility in case something goes wrong with the goat while it's in your care. Okay, so let's get into it. In the case of one who deposits the animal or vessels with another who's acting as an unpaid bailee, you're doing me a favor. And they were stolen or they were lost. So at that point, you're not liable for theft of loss since you're doing me a favor by watching it. That's going to be understood here. We're going to, of course, always start one level more complicated than the simple rule. That's how the Talmud does it. So here we're going to talk about the case where, because let's say you're not going to be liable to me for theft or loss if you were an unpaid bailee, but you will be asked to take an oath that that's what happened. Now, some people, even though they didn't do anything wrong and they would not normally be responsible, would rather not take an oath. Just in case they made a mistake, that they're sure that it wasn't lost or stolen because of their negligence, but what if they're wrong? They would rather not swear an oath. And you have an alternative. You don't have to swear an oath. Instead, you could just pay me for the animal and absorb the loss yourself. No one's forcing you to do that, but some people would rather pay for the animal than swear an oath. And that's the case that the Mishnah is now going to talk about. In the case of one who deposits an animal or vessels with another, and who is acting as an unpaid bailee, and they were stolen or they were lost, and the bailee paid the owner the value of the deposit and did not wish to take an oath that he did not misappropriate the item and that he was not negligent in safeguarding it. Right? So that's the oath you would need to swear in order to be released from liability, that you weren't negligent and that you didn't misappropriate it for yourself. But you don't want to take that oath, not because you think you did something wrong, you just don't like to swear oaths. You'd rather pay a little money and not swear an oath. So in that case, or in the case that he did not wish to take the oath and so you paid, so that will affect who keeps the deposit if it is found or returned. Right? Now that you paid me for it, basically it's like you bought it from me. You made me whole because I asked you to watch the animal. The animal's gone. You paid me for it. Now if the animal is actually found or returned, who gets it? You paid, right? So it should go to you. The bailee may also choose to take the oath. As the sages said, now the basic rule, an unpaid bailee takes an oath, and he is thereby released from the liability to pay the owner. Let's say it was stolen while it was in your care. So if the thief is later found, the thief pays the double payment. When a thief is caught, he has to pay twice the value of what he stole. That's the Torah's penalty on a thief who gets caught, right? If he comes forward and confesses the theft, then he doesn't have to pay the double payment. But if he's caught and doesn't admit it, right, then he pays the double payment. The court forces him to pay that. So who gets the double payment is the issue here. So if the deposited item was a sheep or an ox and the thief slaughtered it, that triggers the fourfold or fivefold payment. We've learned about that. But to whom does the thief pay? Whether it's the double payment or the fourfold payment for a sheep or the fivefold payment for an ox in the last two cases because he slaughtered or sold the sheep or the ox. But to whom does he pay this penalty? He gives the payment to the one who had the deposit in his possession when it was stolen. That's the bailee. When the bailee paid the owner for the stolen item, the owner granted the rights to the item to the bailee. Therefore, if the thief is then caught and he's making the payment, the bailee is entitled to that payment. Whether it's compensation for the item's value, which he paid for, or a fine, which was levied on the thief when he got caught, in both of those kinds of payments, the compensation or the fine would go to the bailee because the bailee paid the original owner. In the case of a bailee who took an oath and did not wish to pay, if the thief is found and required to pay the double payment, or he slaughtered or sold the animal and is required to pay the fourfold or fivefold payment, to whom does the thief pay? He gives the payment to the owner of the deposit, not the bailee. Makes perfect sense. That's the Mishnah. Now the Gemara. The Gemara asks, why does the Mishnah need to teach the case of one who deposits an animal? And why does the Mishnah need to teach the case of one who deposits vessels? Either way, it's a deposit. Why specify animals and vessels if the law is the same? And the Gemara explains both were necessary, as if the Mishnah taught only the case of one who deposits an animal, I would say it is only with regard to an animal that the owner agrees to transfer rights to the double payment to the bailee when the bailee pays for the stolen item. And this is due to the fact that the exertion required to tend to the animal, to bring the animal in and take the animal out, is great. Right? If I deposit a goat with you while I'm going away and you're not even getting paid for it, you're doing me a big favor, right? Because you have to take care. You have to feed and tend and, deal with the goat poop, etc. If I just asked you to watch a suitcase for me that you stuck in a closet, it's obviously costing you much less time and effort. Consequently, when it becomes clear that the bailee was not responsible for the theft of the animal, but nevertheless compensated the owner waives his rights to any compensation that the thief will pay. But in the case of vessels, where the exertion that is required to tend to the vessel is not great, Perhaps we might say that the owner does not transfer to the bailee rights to the double payment of the thief. And that's why the Mishna had to mention both. And had the Mishnah taught only the case of one who deposits vessels, I would say it is only with regard to vessels that the owner transfers rights to the double payment to the bailee when the bailee pays for the lost item. And this is due to the fact that the double payment in their case is not substantial, as that is the maximum payment that he could receive. But in the case of an animal, where if the thief slaughtered or sold it, he might pay the fourfold or fivefold payment, which is substantial, I would say that the owner does not transfer the rights to the double payment to the bailee. Therefore, it was necessary to mention both that these laws apply whether vessels or animals were deposited with the unpaid bailee. Rami Bar Chama objects to the fundamental reasoning. How can the owner of the deposit transfer rights to the double payment to the bailee? But isn't there a principle that one cannot transfer to another ownership of an entity that has not yet come into the world? Classic example, if I say to you, I'm hereby selling you my crop that will grow next year, and you give me, $100 now, we can negate that sale. You can withdraw from the sale. I can withdraw from the sale because that is a non-sale. I cannot sell you something that does not yet exist. I can sell you the rights to what comes from this field for a certain amount of time. That's different. But to say I sell you the specific crop that will come in next year, no, I can't sell you something that does not yet exist. According to the majority, Rabbi Meir would permit those kinds of sales in certain cases. So how does that apply here? Right? If when you decided to pay me, instead, you're the unpaid bailee watching my goat, and the goat is gone, right? So you don't know, was it lost, was it stolen, what? You'd rather not swear an oath that you weren't negligent, you just don't want to swear an oath, so instead you pay me for my goat. So if I'm now transferring to you the rights to the goat, am I also transferring you to you the rights to receive a double payment fine if it should come in? That's what the Mishnah said. But here's the objection from Rami Bar Chama why that shouldn't work. Because the double payment of a thief, there's no guarantee that a thief is going to be found, that the thief isn't going to confess, that the thief is actually going to tender the double payment as a fine. So that double payment doesn't exist yet. So how can we say that when you paid me for the goat that isn't even here, because you'd rather not swear an oath, that I also sold you the rights to receive a double payment from a thief who stole the animal that actually belonged to me at the time that he stole it? And if we say, well, I'm just selling you all rights that could come, yeah, but the right to a double payment, that doesn't exist yet. That's the problem. Right? So, since the thief was not yet liable to pay the double payment when the bailee paid the owner for the item, there was no way to transfer rights to that payment to another person. And even according to Rabbi Meir, who says that a person can transfer to another ownership of an entity that has not yet come into the world, Rabbi Meir's statement applies to items such as the fruits of a date palm, which are likely to come into being as they grow on a regular basis. But there's nothing regular about this thief getting caught and offering the double payment. But here, where the transfer rights to the payment is part of the initial agreement between the owner and the bailee, taking effect when the item was actually deposited, who could say that the deposit will be stolen? And if you say, well, we foresaw that the item might be stolen at the time that I deposited with you, and that you might choose to pay me instead of swearing an oath that you don't need to pay me. And against those possibilities, I transferred ownership to you in the event that you paid me. Then what is there to say, right? And if you say that it will be stolen, who could say that a thief will be found? And even if the thief will be found, who could say that he will pay the double payment? Perhaps he will confess and will be exempted from the double payment. So Rava said in response, it is as though the owner said to the bailee, at the time that he gave him the deposit, when it will be stolen, meaning if it will be stolen, right? But we're in terms of the language of transfer, when it will be stolen, and you will wish to refrain from taking an oath, and you will pay me instead, then if all those things happen, ownership of my cow is hereby transferred to you from this time, right? It's a retroactive designation from now in case all those things happen. And the reason that matters is because that would mean that at the time the animal is stolen, it belonged to you. And that's why you would be entitled to claim the double payment if the thief is caught and tenders that payment. And thus the cow is an entity that already came into the world. Since ownership of the cow would be retroactively transferred to the bailee from the time of deposit, any profits generated by the cow, for example, the double payment, right? It's like a profit in the sense that the thief took it, we worried, but then we got the cow back, and now the thief has to offer a double payment. We didn't expect to be paid twice for the cow. Who's going to get that double payment? The owner. But if you decided to not swear an oath and paid me, you became the owner. But when did you become the owner? You paid me after it was already gone. We're saying retroactively, it would be that you became the owner from now, when I deposited it with you. We are on 34a. Rabbi Zera objects to this line of reasoning. If so, then even the fleece and the offspring of the animal that grew while it was in the bailee's possession should also be the property of the bailee. But why then is it taught in a baraisa that the bailee receives all profits generated by the animal except for its fleece and its offspring? So rather, Rabbi Zera says that it is as though the owner said to the bailee, my animal is hereby transferred to you from this time, in case all those things happen, that it was stolen and you decided to pay me instead of swear an oath, and the thief was caught and the double payment was tendered. So I sell you the animal from now. However, I'm selling you everything of the animal except the rights to retain its fleece and its offspring. So the Gemara asks, if so, why was this law stated in the Mishna without qualification? Our Mishna that we just read didn't have that set of qualifications surrounding it. Does every owner necessarily have that condition in mind? And the Gemara answers, typically, profit that comes from elsewhere, like the double payment of a thief, which is difficult to anticipate, a person is apt to transfer to the bailee because in case that all those conditions should come up, fine, then it will belong to you. But profit that originates from the body of the animal, which can be anticipated, a person is not apt to transfer to the bailee. And some say that Rava says his response differently. It is as though the owner said to the bailee at the time of the deposit, when it will be stolen, and you will wish to refrain from taking an oath, and you will pay me instead, ownership of my animal is transferred to you, adjacent to, meaning immediately before, its theft. It's not that we're making a retroactive transaction if all those conditions come into existence from this moment, but rather, if all those conditions come into being, we're transferring it to you as of a few seconds before it was stolen. So any other profits that the animal generates before that, like, if I was away for a long time and the sheep was shorn of its fleece, or it, gave birth to a lamb, that would still accrue to the benefit of the original owner. And the Gemara answers, and so what is the difference between the formulations in Rava's two responses? And the Gemara answers, there is a difference between them with regard to the difficulty raised by Rabbi Zera with regard to fleece and offspring, which is irrelevant according to the second formulation, as I just explained. Alternatively, there's also a difference in a case where the animal is standing in a marsh at the time of its theft. Since the animal was not on the bailee's property at that time, he could not acquire it. Now, new subject. The Mishnah teaches that if the bailee paid the owner and did not wish to take an oath, that the thief pays the double payment to the bailee. Right? That's what we learned in the Mishnah. Rabbi Chia bar Abba says that Rabbi Yochanan says when the Mishnah says if the bailee paid, it does not mean that he actually paid. Rather, once the bailee said, I hereby choose to pay, instead of swearing an oath, even if he has not yet actually paid, he acquired the double payment and all other profits. Even if you didn't actually give me the money, as soon as you said, I don't want to take an oath, the animal's gone, I'm going to take the responsibility, I choose to pay. Now, at that moment, you acquire the rights if the thief is caught and the double payment comes in, even if you haven't paid me, because you've undertaken the liability to pay me. So even though the money hasn't actually changed hands, you now have a debt to me, right? So once you say I choose to pay, even if the money hasn't changed hands, you became liable for that payment, and therefore the owner of the animal with respect to receiving the animal back if it is found, or the double payment of a thief if he is caught. And the Gemara raises an objection to what we just said from that which we learned in the Mishnah. If the bailee paid the owner and did not wish to take an oath, the thief pays the double payment to the bailee. And the Gemara infers, if the bailee paid, yes, if you paid me, the money changed hands, then yes, you acquired the animal and those rights. But if the bailee did not pay, he does not. It's not when you said you will pay, it's when you actually pay. And the Gemara answers, yes, but look at the latter clause of the Mishnah. In the case of a bailee who took an oath and did not wish to pay, the thief pays the double payment to the owner. And from that, the Gemara would infer that the reason that the thief pays the owner and not the bailee is that the bailee did not wish to pay. But if the bailee wished to pay, then even if he hasn't actually given the money, he acquires the rights to the double payment, right? So the inference from the first clause, in other words, the first clause doesn't come to be, we infer the opposite, but the opposite inference from the latter part of the clause would produce a contradictory thing, right? If you paid, yes. If you haven't actually paid, no, you don't have the rights. But in the latter clause, if you wish to pay, if you do not wish to pay, then the owner retains rights of any penalties that come in. And the opposite of that would, well, if you wish to pay, then the owner has already transferred those rights to the bailee. So since these are contradictory results based on the opposite of paying and the opposite of not wishing to pay, then what can we infer from the Mishnah on this question? Nothing. We can't infer because of these contradictory results. So what do we do? No inference is to be learned from this Mishnah. We can look at the laws that are stated in the Mishnah, but we can't make these inferences because they produce the contradictory results. So the Gemara notes, it is taught in a baraisa in accordance with the opinion of Rabbi Yochanan. In the case of one who rents a cow from another, and it was stolen, and the renter said, I hereby choose to pay, and I will not take an oath, and the thief was located thereafter, that the thief pays the double payment to the renter, right? Not if the renter pays, but if the renter says, I choose to pay, right? Even if he hasn't actually paid the money. So apparently, once the renter chooses to pay, he acquires the rights to the double payment from this baraisa. But Rav Papa says, in the case of an unpaid bailee, once he stated, I was negligent, thereby rendering himself liable to compensate the owner transfers rights to the double payment to him, as if the unpaid bailee wishes, he can exempt himself from that liability by claiming that it was stolen, which an unpaid bailee is never liable for. Admitting negligence is tantamount to agreeing to pay rather than taking an oath. And likewise in the case of a paid bailee, who has a higher level of responsibility. Once he stated it was stolen, the owner, meaning he's liable, right? The paid bailee is liable if it's stolen from him. So once he stated it was stolen, the owner transfers rights to the double payment to the paid bailee, and the paid bailee has to pay the owner. And why does this happen? Because the paid bailee had a choice. He could have exempted himself from the liability by claiming that the animal was maimed or died due to circumstances beyond his control. Now, obviously, he would only say that if it was true, but if he made such a claim, then he would be exempt from paying. Now, by contrast, in the case of a borrower Now, the borrower has the highest level of responsibility since he has it, as purely a favor to him. So any kind of loss he's going to be responsible for. So by contrast, in the case of a borrower who says, I hereby choose to pay, rather than swear any kind of oath, the owner does not transfer the rights to the double payment to him. Why? The borrower's statement that he chooses to pay is ineffectual. It means nothing, as he is liable to pay even without it. Any loss triggers liability of a borrower. Because the statement is therefore ineffectual, it does not confer any rights. With what claim would a borrower be able to exempt himself from payment? It is only with the claim that the animal died due to ordinary labor, right? Meaning it was circumstances beyond his control. He didn't do anything wrong. A case of an animal that died due to ordinary labor is uncommon, and this claim is therefore accepted only with corroborating proof. Now, some say that Rav Papa said in the case of a borrower, once he stated, I hereby choose to pay, the owner transfers rights to the double payments to him, as if a borrower wishes, he can exempt himself from the liability with the claim that the animal died due to ordinary labor. Rav Zeved said to him that this is what Abaye said, a borrower acquires the rights to the double payment only when he actually pays for the item. What is the reason for this? Since all the benefit accrues to the borrower as he enjoys the use of the item without payment, the owner does not transfer the rights to the double payment to the borrower due to his statement that he chooses to pay. Only when he actually makes the owner whole does he then step into the place of the owner in case the thief is found and a double payment comes in or the animal is returned, etc. But once the borrower paid off the owner is the only time that he acquires those rights. Saying he will pay does not get for him those rights. And the Gemara notes, it is taught in a baraisa in accordance with the opinion of Rav Zeved. In the case of one who borrows a cow from another, and it was stolen, and the borrower went ahead and paid, and the thief was located, thereafter the thief pays the double payment to the borrower. And this indicates that the borrower receives a double payment only if he actually paid the owner for the item. The Gemara comments, according to the first version of the statement of Rav Papa, that the owner transfers rights to the double payment to the borrower only if he actually pays the owner. This baraisa certainly is not a conclusive refutation of the opinion of Rav Papa, as the baraisa corresponds to his opinion. According to the latter version of Rav Papa's statement that the owner transfers rights to the double payment to the borrower, even if the borrower merely says that he chooses to pay, shall we say that this baraisa would be a conclusive refutation of the opinion of Rav Papa? And the Gemara answers, Rav Papa could have said to you, is the baraisa stronger than the Mishna? That's always going to be a no. Is the baraisa stronger than the Mishna, which teaches that the bailee receives the double payment if he already paid the owner? And nevertheless, we establish that the Mishna is referring to one who states his intent to pay, but has not yet paid? Here too, establish the baraisa as referring to one who states his intent to pay, but has not yet paid. And the Gemara questions this, are these cases comparable? There in the Mishnah, it is not taught that he went ahead and paid. Here in the baraisa, it is taught that he went ahead and paid, which indicates that he actually paid, and not merely that he agreed to pay. And the Gemara responds, what is the meaning of went ahead? It means that he went ahead and stated his intent to pay, although he did not yet actually pay. And the Gemara asks, but from the fact that the Tana teaches the law in the baraisa cited earlier with regard to a renter with the formulation, and he said he would pay, and in the baraisa with regard to a borrower, the Tana uses the formulation went ahead and paid. So conclude from it that the baraisa concerning a borrower is teaching specifically that he actually paid, not just that he said he would pay. And the Gemara rejects this proof. Are these two baraisas taught together so that one can draw a conclusion based on a discrepancy in their formulation? Perhaps the baraisas are unrelated and are simply formulated in different styles, and we can't draw these matching inferences. So the Gemara comments, the sages asked the Tanaim of the school of Rabbi Chia and Rabbi Oshaya, experts in Mishnayos and baraisas, if these baraisas were formulated together, and they said that yes, the baraisas were taught together as one long baraisa, and therefore one can draw a conclusion based on a discrepancy in their formulation. Next subject, the Gemara comments that it is obvious that if the bailee initially said, I will not pay, and then said, I hereby choose to pay, rather than taking an oath, he is entitled to the double payment, as didn't he ultimately say, I hereby choose to pay? The Gemara raises a dilemma. But if he initially said, I hereby choose to pay, and then said, I will not pay, then what is the law? Do we say that he is retracting his intention to pay, and therefore he has no right to the double payment of a thief if the animal should be located and the thief caught and the double payment comes in? Or perhaps he stands committed to his initial statement that he would pay, and then when he says, I will not pay, he is merely postponing that payment to a later date, but his obligation to pay remains, and therefore his rights to receive the penalty of the penalty payment of a thief if he's caught would remain his to receive. And then the Gemara raises another dilemma. If the bailee said, I hereby choose to pay, and then he died before paying, and his sons, meaning his heirs, said, we are not paying, then what is the law? Do we say that they are retracting their father's decision to pay? Or perhaps they stand committed to fulfilling their father's statement and they are merely postponing payment to a later date when they will be able to pay? The Gemara raises another dilemma. If the father died before he declared his willingness to pay and the sons paid, what is the law? Can the owner say to them, when I transferred rights to the double payment, I transferred them to your father who pleased me, but to you I did not transfer those rights? Or perhaps this case is no different, and the owner transfers rights to the double payment, provided that he receives payment, and it does not matter whether it was the bailee or his sons who paid him. I'm almost done for today. Questions or comments, please get them in. If the owner of the deposit died and the bailee If the owner of the deposit died and the bailee said, and the bailee paid the payment to the owner's sons, then what is the law? Can the sons say to the bailee, when our father transferred rights to the double payment to you, it was because you pleased him. But as far as we are concerned, you did not please us. Or perhaps it is no different, and the bailee receives the double payment. Likewise, if both the owner and the bailee died, and the sons of the bailee paid the sons of the owner, then what is the law? You notice we haven't answered any of these long list of questions. Can you guess where we're headed? The Gemara raises yet another question. If the bailee paid half the value of the deposit before the thief was discovered, then what is the law? If one borrowed 2 cows and they were stolen, and he paid the value of one of them, then what is the law? If one borrowed an item from partners and he paid one of them, what is the law? In the case of partners who borrowed an item and one of them paid, what is the law? If one borrowed an item from a woman and paid her husband, what is the law? In the case of a woman who borrowed an item and her husband paid for the deposit so she would have to swear an oath, what is the law? In all these cases, the dilemma shall stand. Taiku. Meaning, all these dilemmas were asked, but they were never answered. They couldn't figure it out. And later commentators didn't figure it out either. So if one of these cases comes up, what do we do? All of the dilemmas raised by the Gemara in this passage remain unresolved. The Rif and the Rambam write that since there is uncertainty concerning who is entitled to the payments, they are divided equally between the owner and the bailee. If one of them seizes the payment, the other cannot reclaim it. According to Rabbeinu Yitzhak of Dampierre and the Rosh, the owner maintains presumptive ownership of the payments, and the burden of proof to establish rights to the payments would be upon the bailee. And since there is no proof, he does not receive any of the payments. As we see, there's different commentators holding different ways to address these uncertainties. So it would depend which rabbinic court you came before if you were adjudicating such a case. That's what we've got for today. We're about halfway down page 34b, but it's a good place to break. And tomorrow's class should be approximately the same length as today's, God willing, just in terms of how much material we'll cover. So we'll pick up page 35 tomorrow from this location on 34b. Bill, so small tangent on the law against transferring something that has not yet come into the world. It is acceptable it is acceptable to say, for example, you are buying the produce of field A in year B. Does that mean that futures commodities contracts, as they are traded on a daily basis today, are acceptable if the contract is phrased with reference to a specific source of the commodity, this field or this mine or this forest, or are they unacceptable per se? I mean, it's a great question. I guess it's according to Rabbi Meir that you could definitely say the dates that will grow on this tree, I'm selling them to you now. Because we know that the dates are going to come in. But that's just the minority opinion of Rabbi Meir. Right? The majority say you can't sell something that does not yet exist. On the other hand, we know that you can sell the rights to what comes from this field for a number of years. So I think that you got it right, Bill. It really is about the wording, what you can sell, so that what you're selling is the rights to take what comes from this field. That's what you're selling today, not a particular crop or quantity that you expect to come, right? Now, futures contracts, I think, probably are worded that way. So what do? I mean, I'm so far from being any kind of an expert in this area, but I'm sure that there are, Orthodox Jews working in the commodities business. So, I'm sure that there's some kind of an understanding of how they can do it. And it's very much based on what you're saying, that there might be underlying rights, but what they're buying and selling is a financial instrument that exists today. More than that, I'm speculating. Joseph, just a big picture question. Since the laws of business is one of the most important aspects of Talmud by which one will be judged, does this mean that the sages likely see this section of the Talmud, as one of the most important to learn? Right. Well, you're never going to say that one area of law is more important than another, right? Even you wouldn't say that, that the law of saying brachas or honoring your parents, right, which comes up every day, you wouldn't say it's more important than the law of the red heifer, which we haven't been able to enact in 2,000 years. But learning it, right, is all of equal importance. What you can say is, okay, it's all of equal importance, but where will people focus more time, and where will they start the education of young people? And in that sense, yes, the laws of commercial transactions is something that people will spend more time on because it comes up so often, because people are engaged in business every day, because we'll be asked when we come to the next world, were you honest in your business dealings? And that's not just saying that I was an upright person. It means that you have to study the laws of business so that you could make the right choices in your business dealings. In that sense, yes, it's tremendous importance on that. And that's why, as I mentioned, that chapter 2 that we just learned, is where children who learn Talmud, in a religious school and start in 5th grade, they start with that chapter, the laws of lost and found objects, because that's a kind of complicated and yet straightforward and ever applicable set of laws that are never gonna, they're never gonna become inapplicable or irrelevant. As long as there are people in this world, objects will be lost, right? There might not be a holy temple standing, there might not be high priests serving in it, until Mashiach comes, but people will be losing objects and others will be finding. That's what I've got for us today, and with God's help, we'll be together again tomorrow, Wednesday, at the regular